All rise, we will obey. The International Criminal Court is now in session. Lord John de Co-Panel International at Uwait. Please be seated. We have sir.
Yes, good morning all. Can you call the case, please, Madam Registrar?
Good morning, Madam President, Your Honors. Situation in the Republic of the Philippines in the case of the prosecutor versus Rodrigo Duterte. Case reference ICC 0121-0125. And for the record, we are in open session.
Yes, could we have the appearances, please, prosecution first?
Good morning, Madam President. Good morning, Your Honors. Good morning to everybody in the room. Today we are Edward Jeremy, Robin Croft, Hannah Allen, Erasmus Lovell Jones, Emma Norton, our case manager James Meriti, and Maria Berdenikova, and I'm Julian Nichols. Thank you.
Thank you, Mr. Nichols. The defense, please.
Good morning, Your Honor. Kate Gibson, my co-counsel, Alex De Sevidavi, a legal assistant, and Assistant Counsel Sondrine De Senna, and I'm Peter Haynes. It's a pleasure to be here.
Mr. Haynes, just before you sit down, just so that the public understand, I think that Mr. Duterte asked to be excused from the hearing.
Indeed, that's correct, Your Honor.
Yeah, thank you. Yes, and sorry, not finally, no, the representatives of the victims, please.
Good morning, Madam President, Your Honors. The common legal representative of victims team is composed today of Mr. Joel Butuyan at my right. Behind us, Mr. Orcholon Naransetsek and Ms. Ludovica Petruccio, legal officers, and on the other bench, Ms. Ann Grabowski, legal officer, and I am Paulina Masita.
Thank you very much, Ms. Masida. And the registry, please.
Mr. Dubuisson, thank you, Madam President. Good morning, Your Honours. For the registry this morning, by my side, we have Fatia Balfas, who is the jurist from the VWS section. There is Natalie Wagner, who is a coordinator within my office. There's Marie Lucas, who's a jurist for the detention. And also for my office, accompanied for more specific matters, if you seek to delve more deeply, there is Asma Yacoubi, who is the chief of the LSS. There's Philip Ambach for the head of the VPRS. And there's also Rod Rastand, who is the head of Judicial Cooperation Support Section. I am, of course, Marc Dubuisson, director of the Division of Judicial Services. And I am representing here the registrar this morning. Thank you.
Yes, thank you very much, Mr. Dubuisson. As everybody knows, this is the first status conference in this case, and the first proper hearing, I suppose you could say, for the trial. And there are a few things I want to say before we move on to the agenda. As everybody knows, the independent expert review published in 2020 stated that one of the tasks of the experts who had been appointed was, and I quote, to enhance, by the making of recommendations, the performance, efficiency, and effectiveness of the court and the Rome Statute as a whole. Since its publication, all organs of the court have put in place measures designed to achieve those obvious and laudable goals. In respect of trials, efficiency and effectiveness is dependent on actions taken by all parties to a trial. The prosecution, the defense, the victims' representatives, the registry, and last but not least, of course, the judges. It depends on them, all of them, cooperating procedurally. Such cooperation does not in any way affect the fairness of a trial, nor the onus on the prosecution to prove its case, nor does it encroach on the rights of the accused. It is a truism, but one which bears repetition, to state that the overriding objectives of a criminal trial, for judges in particular, are, first, the acquittal of the innocent and the conviction of the guilty. Second, dealing with the prosecution and defense fairly. Third, recognizing the rights of the accused, particularly those under Article 67, and any other rights which are germane to a trial. Respecting the interests of witnesses, and last but certainly not least, respecting the interests of victims. In order to achieve efficiency and expedition of a trial, there must be, amongst other matters, first, an early identification of the real issues in the case, and I emphasize that and will return to it later in this status conference. Proper use of agreed fact between parties. Presentation of evidence, whether disputed or not, must take place in the shortest and clearest way. That is particularly important in this trial. Avoidance of unnecessary and lengthy legal arguments. We encourage the participants to cooperate in these goals and generally between themselves. To give but one example, any requests for disclosure should be discussed between the parties before rulings are sought from the judges. It is incumbent upon the prosecution to give proper reasons if they are going to refuse a request for disclosure. Finally, let me say this. We are delighted to see from the submissions that have already been made that the parties and participants are represented by highly experienced counsel on all sides. And we are heartened, as I say, by the responses which we've received to the scheduling order for this status conference. Those responses show that cooperation exists, and we are optimistic that it will be unnecessary for the trial chamber to enforce compliance with directions made in the exercise of our not inconsiderable powers of case management, which we will employ to achieve efficiency and a fair trial. So having said that, can we move straight away to the various issues in the order in which they were set out? Firstly, obviously, is the start of trial. There appear to be a number of different suggestions. The Office of the Prosecutor says the 30th of November. The defense doesn't want to give any date at all until matters are resolved, such as the accused's fitness. The legal representative of the victims wants beginning of September, and the registry wants January because of interpretation, which I will come back to. Okay. Does anybody want to say anything more? There is actually one matter, Mr. Nichols. Yours is your start date of the end of November is because you say it'll take you until September to complete disclosure. Is that right?
Thank you, Your Honors. You'll find this at paragraphs 3 to 5 of our submissions.
Yeah.
What I can say is that we've taken a hard look at the, I believe, 11 tasks in paragraph 5 that we need to fulfill in a reasonable time before the start of trial. And so in picking the September 30 date, that was not random. It was made in the spirit of efficiency and expedition that you have highlighted. And we believe that is a date that we can meet that will not be easy to meet. It will require us to work hard and efficiently. And then we picked, and of course it's up to your chambers entirely, what we thought was the soonest reasonable start date after that. But we really do think we need that time in order to accomplish all of those different things, different tasks that we need to do. And we think that if we have that time, I mean, I know everybody always argues this, but ultimately the trial will be more efficient because we won't make mistakes and we'll have everything done properly and disclosed properly. Some of that, you know, we have new counsel now, and Mr. Haynes and I have done a trial before, and we know each other. So I do think we'll be able to cooperate. As you say, we haven't had a chance. We've met and said hello and had a coffee, but we haven't sat down yet to really discuss what can be agreed on, what can be stipulated to. So hopefully that will make it more efficient. But you know, we've calculated in that date of 30th September that the August break doesn't exist, essentially, and that we will keep going through that period. That does not include everybody taken off for 3 weeks. So I can't really add more, and I'm actually going on too long to be efficient, but I rely on our submissions, and we really think that is the time we need.
Yeah, well, okay, Mr. Nichols, I mean, I see that. I mean, you're actually assisted in one sense by the fact there has been a change of counsel, because that obviously causes, well, you're assisted in many senses, I feel, but because of the need for them to get to grips with the case. However, can I emphasize, however, that you really must do things with expedition. We weren't madly impressed by the delay in asking for the matters in your last motion, as you saw. So we'd like you to get on with it. All right, Mr. Haynes.
Could I make just one additional point? I'm sorry, just that with this schedule we proposed, other than one case, it would be the fastest from confirmation to trial. I know that doesn't mean that those other cases, that should be the measure, but we were thinking in terms of making this as quickly as we could, and I will, you're correct, of course, about the motion you referred to, and I can address that later. That was our mistake. We own that. There was a miscommunication where we believed that those items were not in custody, but I will address that if you wish later.
Well, no, I think we've given you the warning, so that'll do. Mr. Haynes, is there anything you want to add or say? I appreciate.
Yes, I think what's important for us is that whatever trial date Your Honour fixes upon, you do not, as it were, concertina the gap between that date and the end of disclosure, which has traditionally been no less than 3 months. And so if the prosecution's aspirations are to conclude that and its other tasks by the end of September, then that would mitigate in favour of a start date in the middle of the Christmas vacation, the 30th of December, which would be 3 months later, which has a certain synergy with the other ball in the air, which is the interpretation, which doesn't appear to be ready until January. So that would all tend to suggest that the start of the trial could not be this year. We will be ready for whenever you want it to start, but our anxiety is that that should not be a date which leaves us with perhaps 1 or 2 months after the end of prosecution disclosure. It should be a minimum of 3.
Yeah, but there are pressing reasons which mandate that we really should start this trial as soon as possible, which is basically the health of your lay client. And I appreciate the interpretation, for I'm going to come to that in a moment. But all right, Mr. Haynes, I've got your non-submissions.
Well, for the avoidance of being unclear, if the start date is going to be this year, then Mr. Nichols and his team are going to have to do a little better.
Yes, we'll come to that. Right. Yes, Ms. Masida, your submissions are it should start as soon as possible. I've got that.
Thank you, Madam President. 30 seconds of your time. I don't have to stress the obvious here. Victims would like this trial to start tomorrow. That's as simple as such. However, after the submission of the parties, we had further consultation with our clients. They are amenable to start this trial. 30th of November seems to them at the moment still a reasonable period of time. January 2027, no. For them it's too long. And going to what my learned colleague was saying, well, we can start the trial already in November and hear witnesses who can speak English. This will allow to start and continue the trial and solve the issue of interpretation starting in January 2027. Thank you very much.
Yes, okay, Mr. Dubuisson, this is the same problem that arose in Al Rahman, that you don't have interpreters ready as yet to deal with the 2 languages that are apparently going to be spoken by some of the witnesses. However, as we did in Al Rahman, and as Ms. Masida has pointed out, it is possible to start the trial with witnesses who only speak English. And my understanding is that it's not as complicated as finding interpreters as it was in the Al Rahman trial in a language that was only spoken in a small part of Sudan. Because presumably, as court proceedings in the Philippines are all in English, there must be interpreters there, and equally field interpreters who can be trained more speedily, I would have thought, than was possible in the Al Rahman trial.
Mr. Dubuisson, thank you, Madam President. Yes, I take note of what you've just clarified, in addition to what my colleague Ms. Masida just said. Indeed, there are a number of items we need to look at here. Who are we interpreting for specifically? We're interpreting for the witnesses. Today we have a number of witnesses for which we know that they will testify in English. We have been warned that there are some witnesses that will be speaking in 2 other languages of the Philippines. So we need to find, if possible, interpreters who could speak these 2 languages. That's very important for us. To date, we do not have knowledge of who these witnesses are. So, as you have just said, we're going to try and recruit people principally from the field, that is field interpreters, but of course we do have to train them, because field interpreters working out in the field work in the consecutive or in whispering, chuchotage form, but we are going to be using simultaneous interpretation, so they need to be prepared and trained. Not into English, fine, but into the other languages such as Tagalog, those languages that are used in the Philippines. But of course it is important also for the witnesses and for the population that outreach is conducted with regard to the trial that is ongoing in The Hague. So it is important for those out in the Philippines to be able to follow the trial that is ongoing here in The Hague. This is something that we are always attentive to, but it is not our top priority. Our top priority is the language of the accused and the languages of the witnesses. And this is why, with regard to what has just been said, yes, were we to go ahead with the opening statements, if you wanted to have these at the end of November or at the end of the year, yes, indeed, we could find solutions for interpretation for a number of hearing days for those opening statements. But if we're talking about bringing witnesses to testify on a regular basis, then we need to be properly equipped in terms of interpretation booths. And that is why we would like for the trial to commence at a later date. I'm also very aware of the fact that we will need to adapt the hearings according to other criteria that you will determine, yes or no, to do with the accused, and this will enable us to save time. So, for example, if we have shorter hearings, we would maybe be able to improve the training terms and time, but that would only apply to maybe a month or a month and a half in terms of time. So for us, it would be better to start after a 6-month period, that is to say 6 months after today.
Yes, thank you, Mr. Dubuisson. Well, as I say, we're going to consider all these matters. We'll give the date that we propose to start at the end of the status conference orally, and we've heard all the submissions. All right. Can we move then, please, to the next item on the agenda, unless there's anything anybody else wants to say? No. And that's the number of witnesses. The prosecution, Mr. Nichols, it's paragraph 6, thinks that you want to, the prosecution intends to call 60 to 70 witnesses, including approximately 31 insider witnesses. Is that right?
Yes, Your Honor. I think...
I'm looking at paragraph 6 of your submissions.
Yes. I think we can rely on our submissions for this question unless you have any other follow-up.
No. Yes. Well, only this while we're on the topic of witnesses. We'll set the number of hours at a later stage. But and can I say to all parties, we will do the same as I think most trials do now, and that is you'll just be given an overall figure as opposed to timing for every witness. But there is one thing. What emerged as a problem in the last trial of Al-Rahman was the fact that witnesses to the same incident were called months apart, as a result of which discrepancies and things which could have been resolved had they been spotted were not spotted. If we say, as I think we'll have to, given what the registry says, that we're going to start the trial earlier, but they won't have their interpreters ready until the new year, and you deal with them in English, you deal with those who can give evidence in English, rather. What we would all still like is for you to try and call all the witnesses to the same incident consecutively. It makes life very difficult afterwards. Is that something that will? Well, I don't expect you to answer that straight away, but I think it's something we'd like you to consider.
Well, thank you, Your Honor. Yeah, of course we would want to do that. Without rehashing the last trial, it was the interpretation that threw that off because we had to just choose whoever could speak the standard Arabic at the time or in English. I think it will be less of an issue in this case because the case is different in that it's not sort of three big incidents with many witnesses for each of those.
It's a lot of incidents.
It's a lot of little incidents which are fairly discrete, which rely on fewer witnesses per incident. So we will try to do that. If I could just go back to the translation, not to complain, but we did raise this early in order to try to get a head start. We sent a notice on 13 March, I believe, of the languages. My understanding is that nothing can happen until after the confirmation decision, but I just wonder if it can be speeded up, because 6 months is a long time, not just for the courtroom presentation, but some of the feedback that we received that my friends representing the victims would know better is that, as Mr. Dubuisson said, there's a lot of interest in this case in the Philippines, and having it not broadcast, I know that's not the main point, and we don't always do that, but it'd be much, much better for the population and the victims and people interested in this case if it could be broadcast in Tagalog or the other languages. So if we start with all English-speaking witnesses, that will require us to jump around a bit, although we will try to keep it as coherent and focused as possible on the particular incidents. But it means at the start of the trial that some people won't be able to follow as well as they should, and that would be a shame. That would be, I think, part of what we try to do here is make this accessible to the population for the situation in question. So if there's any way to speed that up, that would be excellent.
Yes, well, as I said to Mr. Dubuisson, my understanding is that the court system in the Philippines operates in English, and if there is real interpret, I may say I was quite surprised. I rather was under the impression, and have been told by people who come from the Philippines, that most people there did speak English, but I'm told that's, what you all tell me, that's wrong. But certainly the court system must therefore have ready and trained simultaneous interpreters.
Yes, Your Honor. I have to say it was not something we had foreseen until we heard after the confirmation hearing and got this feedback. But it's also likely that some of the population from which a lot of the victims in this case were drawn do not speak English. It may be that most people do, but I again defer to my friends, but that some of the poorer community where many of the victims are from do not have a good command.
Yes, all right. There's one other thing. I mean, it will be specified in the conduct of proceedings, but I note that a lot of these, the witness evidence is in the form of suspect interviews. Right. Can I make it clear straight away, as I say, it'll appear in the conduct of proceedings, where there are lengthy interviews which wander all over the place in terms of topics and whatever. Before the witness is called, the chamber will expect to have a breakdown in schedule form of the topics which are to be gone through the witness in the order of which they are to be gone through, with a reference in a column to the pages in the actual interview, because, as I say, our experience, certainly my experience from the last trial, was that, as so often happens in such interviews, topics were returned to over and over again. So can I make that clear right away?
Absolutely, Your Honor. We expected that. We've discussed how to do that best, and we plan to do that. I would say that affects, in the most part, 5 witnesses especially. And so we intend to provide very detailed summaries, and we'll put them in the format that the court, we will create those schedules, and we will also take care with the summaries for those insiders with lengthy transcripts.
Right. And the last thing is, and I think that's a general comment, it really is incumbent, as I say, in particular because of this case, because of the health of the accused, that the evidence is kept to the minimum possible, and the Chamber would not expect to hear from witnesses all saying the same thing. And I know Mr. Haynes objects to it, and I'll come back to that, but we'd expect as much use of Rule 68.3 and 68.2b, I think it is, as possible.
Yes, we would plan that. That is something I was going to address.
Yeah,
We would like to, I mean, the experience of the last trials has seemed to work well. I think the jurisprudence, I won't go into it now to check, is so there is no unfairness whatsoever in using 68.3. It's available to both parties. It makes things more efficient in every way, and we intend to use it. In terms of the length and how much the witnesses need to testify, I think that may be something where we can cut that down. Some of these facts may not be in dispute about a particular murder. We may be able to narrow it to the issues in dispute, which would make the testimony much shorter if the actual fact of this murder or this incident is not in dispute and we're talking about linkage, etc. So we may be able to speed it up.
Yes, well, I'll come back to that when we come to your documentary. Yes, right. Mr. Haynes or Ms. Gibson.
Nothing to add about that.
Right. Ms. Mazzina, anything?
No, Madam President, thank you.
All right. Right, next then, the next topic is, I suppose I may as well deal with it here. Yeah, I'm sorry, before I move on, Mr. Nicholson, I meant to say, the defence did say you should provide at the earliest possible time a provisional witness list. Can I say I agree with that?
We agree too.
Right.
We'll do that 5 months in advance, the provisional witness list. It's already the list from confirmation, obviously.
Yeah.
But we will provide an updated one 5 months in advance, which I think is what was requested.
Right, thank you. Okay, expert witnesses. You seem to be, sorry, Mr. Nicholson, you again then. You seem to be calling an awful lot. On the face of it. I think all we want to say at this stage about it is this, that we're going to propose, I think, that there is a deadline of the 24th of August to provide a list of your experts and their reports, if possible. It would be helpful if, again, as in the Al-Rahman trial, defence and prosecution could agree on the nature. And yeah, well, I see Ms. Macedo wants to say something in a moment. At the moment, it seems to me it's the defence and prosecution that could agree on the nature of the experts to be called. But I will say this. Firstly, if these are going to be experts that are not on the registry list, you should inform the registry as soon as possible who you want to, because more checks are being done these days on expert witnesses. So it's really important that the registry is given advance notice. Second, if objection is going to be taken by, and this applies to experts called on by both sides, to either the expert and the expertise of the particular expert or the content of the report, again, that must be notified to the trial chamber well in advance of the expert to be called. And if there's going to be any legal argument about it, particularly involving a voir dire, then that must be notified as early as possible. And I say that applies to both sides. Mr. Haynes, anything you want to say about that at the moment?
Just a couple of things, and I do hope Mr. Nichols will forgive me if we are holding a conversation across the courtroom. It's merely the fact that we haven't had the opportunity to have a lengthy conversation, as he's already alluded to. I just wondered whether the prosecution experts have yet been instructed, how far advanced their reports are, and whether he's confident they could be served by the 30th of September of this year.
Oh, well, we had in line earlier than that, actually.
I'm grateful for that, but the note I made was the 30th of September.
I thought I said the 24th of August.
24th of August, yes.
Yeah, I did. Mr. Nichols.
Yes, we have instructed some of the experts. They are underway on their reports. I think we will definitely be able to meet the 24th for the list, which will likely be narrower than what we're looking at here. Part of it depends on some things in the works. As far as the provision of the reports, it's hard for me to say. That may be difficult for some of them, the 24th of August, but we will
Well, I think
follow your orders. As I could say, it's moving. We have instructed the experts. They are working. I need to check, essentially, and I think we could meet that very likely for the most kind of important reports. But there may be a couple. There's a couple things where we're waiting on outside parties, and I leave it there, I think.
Yeah, all right. Yes, Ms. Mercedes, you wanted to say something?
Yes, Your Honor. Actually, it was the same question that my colleague Haynes posed to the prosecution about if the experts were already instructed or not, for one very simple reason. Some of the experts are also interesting for us, so we were thinking of joint instructions to save time of the court. Maybe we will liaise with the prosecution and see what can be done yet. Thank you so much.
Yeah. All right, and I'll say one other thing about experts at this stage. Again, it will appear in the conduct of proceedings, but and that is this: if the side who's not calling the expert intends to show documents during the course of a cross-examination to an expert, they must be provided to the expert in advance of the hearing. As I say, that will appear in the conduct of proceedings. Right. The next item, is anybody want to say anything else on that? Does the registrar, Mr. Dubuisson, want to say anything about experts, other than, obviously, early notification?
Mr. Dubuisson, as you indicated, and rightly so, we currently have a vetting system which is much more advanced to circumvent any problems. So it would be worthwhile to be informed of experts ahead of time, so that through these three ways of vetting an individual, we can get from A to B. Thank you.
Yes. Next, the use of AVL. The answer, I mean, I don't think I need to say anything else about it. Mr. Haynes, you say it should remain limited and subject to prior judicial authorization. What did you do during COVID?
Stayed at home.
Yes, and did everything on AVL.
Yeah. I mean, I do have one, I hope, helpful observation, and that is, of course, the big difficulty with AVL in this case is the time difference.
Yes.
Ever since the 15th of May, my phone pings regularly from 4 o'clock in the morning onwards, and you can't get anybody after 4 o'clock in the afternoon. And I think it's going to apply both to those who appear on a video screen and those who are brought here, who are going to need, I think, a couple of days acclimatization to the new time zone they're in. So I think that is going to be a practical problem with AVL in terms of hearing people who are on the other side of the world. Please don't pay too much attention to what appears in the submission document. You will notice its proximity to the date of my assignment.
Yes. Can I say that I agree with, I mean, that is, I was going to raise that anyhow, Mr. Nichols. It's going to be really difficult if they are testifying from the Philippines, because we'll be sitting at something like 6 in the morning, won't we?
We'll have to work that out, Your Honor. In my last job before here, there were sometimes video links that, well, I was present, and it started late at night in the other jurisdiction. We're cognizant of that, and we will only apply for video link when it's impossible to get the person here. So it will be as limited as we can make it, because we would rather they be here. There may be some witnesses who just can't for different reasons.
Yeah. All right. Well, as I say, I don't think there's anything else that needs to be said about that. You don't need judicial authorization. You can, subject to the timings, you can just make that arrangement. Other documentary evidence is the next item. Yes. Now, let me just go through that. You say you're currently, OTP is currently in the process of determining the overall. Yes, you've got 619 items. Wait a minute, it says paragraph 13. Oh yes, it's it's the speeches. That's right. I want to query with you. 197 speeches seems to me, on the face of it, and without, it's probably not the right word, but it seems to me too much, particularly if they all say the same thing. And I think you need to consider fairly carefully whether you need all 197.
We're definitely not going to intend to play all those in court. We will go through them. These are that will be narrowed. That was, I believe, meant, and Mr. Jeremy may need to help me here in a minute, but that was meant, that's sort of the universe at the moment, and they're sort of, we will make careful selections. We don't intend to introduce, I'm sure, all 197 of those.
Right. Now, the point which is made in the defense submissions is this question of whether documents need to be submitted, go onto the court record through the submission or admission system. I'll let Mr. Haynes address us on this, but the submission system of evidence getting onto the record is now court-wide. I think all trial chambers accept that's the way of doing it. However, as a result of the experiences in our last trial, where there was a whole lot of, in our view, unnecessary and irrelevant evidence that was dumped into the court record through largely the admission of very large documents, even though a witness had only spoken as to one page, or even worse, through the bar table motion, this chamber is going to try and find a fine line between the two systems, which we haven't quite worked out, but will appear in the conduct of proceedings. But one of the things that we have in mind is that where documents are relied upon heavily by either party to the proceedings and considered to be important, and I take into account the argument mounted on behalf of Mr. Haynes, which has been said on many occasions, that it makes it very difficult to know at the end whether the chamber will find the document to be persuasive or unpersuasive or even admitted at all. And so I think we are going to say, just so that you have advance warning, that where a particular document is said to be important, we are going to say that we will decide on admission or not at that stage when it's presented. But as I say, what I'm anxious to avoid is wholesale, as I say, dumping of documents through the bar table motion. Videos of visits to the country did not seem to help the chamber much in its last case. So that's really all that I want to say at this stage, unless there's anything else. Oh, yes, I'm sorry, there is one other thing. If you're going to want to introduce evidence from open sources, which includes Facebook or any other social media platforms, then we want to know if you're just going to put them in or whether you're going to be calling expert evidence. When I say open source, I mean material that is not directly attributable to a witness or anybody who can speak about it.
Okay, that's understood. We'll look at that.
Yeah.
Thank you.
Yes, Mr. Haynes, anything you want to say?
No, thank you, Your Honour.
Right. Ms. Masida, anything you want to say?
No, thank you.
All right. I take it the registry has no observations on this. All right. Well, Rule 68 we've more or less dealt with. I think we'll leave it to the parties to see what agreement can be reached on 68. As I say, and as Mr. Nichols says, it's quite 68.3 is quite a good way of getting the evidence in. And yes, and we encourage the parties to discuss that, really. Well, I suppose the only thing, Mr. Nichols, would you be using Rule 68.3 for any of the Article 55 witnesses, or trying to?
Yes, that's possible. I think so.
Yeah. All right. Well, I think we'll see where we get to that. Mr. Haynes, I don't expect any submissions on that at the moment. Agreed facts. Next. Happy to see that everybody is going to talk about this still. The only, we encourage, as I've already said, we really encourage agreed facts. There must be quite a lot in this case because it's a matter of public record what the accused said or did, or in some stages, in some senses. The only question, I see that, Ms. Masida, you submit that the legal representative of victims should have a say on this. The article actually talks about prosecution and defence. I think if you want to, obviously you should be supplied with potential agreed facts, but I think if you want to address us, or if you want to make submissions on it, you'll have to apply for leave.
Thank you, Madam President. I am guided. If can I have 1 minute on this issue?
Yes.
Thank you very much. First of all, two things very briefly. One, it has been court practice to allow victims to notify the chamber if they have or they have not any matter to raise in relation to agreed facts raised by the chamber. And second, in deciding, the chamber shall take into account also the interest of the victims. So on that basis, we submitted already that we should at least give an opportunity to have a say on whether or not the agreed facts agreed by the parties may raise an issue for the victims. It remains, of course, entirely with the parties to discuss. We don't want to be involved in that, but we simply request the notification of the agreed facts just to check whether or not these may have an impact on the interest of the victims and eventually raise that with the chamber. And it's something that can be done in a very quick way. If I can also make this point, if we are notified of the agreed facts, it will take for us not more than a few days to verify whether or not the interests of our clients are indeed concerned. Thank you.
Well, you say that's been the practice. I mean, you quote what you don't actually say which case it was, but I am assuming from the date that it was Lubanga in your footnote 12, at paragraph 10. But what you rightly say is that Rule 69, which deals with that, apart from saying it's the prosecution and the defence, it's for the chamber to decide whether the chamber may consider such an alleged fact as being proven, unless the chamber is of the opinion that a more complete presentation is required in the interests of justice, in particular the interests of the victims. So before we even get to that, we have to decide whether if we're satisfied that something is proven, then it's for us to decide before, and it's only if we take the view that we need more information or more complete presentation that the victims come into it.
Well, Your Honor, with all due respect, sometimes the chamber may not be aware of facts or circumstances that the legal representatives are aware of because we maintain the direct contact with the victims. So in this sense, for us, the notification is important because we can confront what the parties have agreed with what the views and concerns of the victims are. And second, going back to the practice of the court, in the Abdallah Rahman case, we notified twice our agreement at the pre-trial stage. Can't remember now the filing. I'm looking behind me. Someone can find that. At pre-trial in the Abdallah Rahman, there were already a list of agreed facts. And if my memory is still good, I hope so, in both cases, there is a filing of the then appointed legal representative notifying the chamber about no opposition of the agreed facts reached by the parties. So it's not an ancient practice of the court. It's a practice that has been prolonged in a number of cases before the court. I leave it to the discretion of the chamber, but I wanted to make the point because particularly in this case, it's important for victims to be fully appraised of what's going on. Victims are very interested in this case. And for them, it has an impact if a fact is already agreed or not agreed. Thank you.
Yes, well, we'll take that, your submissions under consideration. Yes, thank you. Unless there's anything else on that before... yes, Mr. Nichols.
Just, I think in the last trial, I think, agree with Your Honor, the defense and I agree and the prosecution agree what they can, and then the LRV is notified that this agreement has taken place, and we submit them, but I think that's where it ends.
Well, that's my impression, but
Yeah.
I hear what Ms. Maceda said. I just think it would be unfortunate were there to be intervention when facts which have been agreed between the defense and prosecution, who are the parties to this trial, and with the laudable view of increasing the efficiency, I would be reluctant to see it being derailed at any stage. But as I say, we'll return to you on that, Ms. Maceda. All right, finally, before we take the break, languages, I think we've really discussed that, haven't we? Except the only thing that, Mr. Haynes, I was slightly surprised to see was that you wanted interpretation for your lay client, who, as I understand it, as president of the Philippines, ex-president of the Philippines, an ex-lawyer in the Philippines, speaks fluent English.
He won't need interpretation.
Right, thank you. Yes, unless there's anything else on interpretation, I think we've actually discussed that already. Anybody else want to add anything? No. All right. Well, it seems to me, because we're then coming on to disclosure, which will be slightly longer, I think, we'll take the break at this stage and sit again at 11 o'clock.
All rise, we will be.